Hello everyone, good afternoon to all of you and welcome to the session on a special webinar which we have organized under the aegis of School of Law UPS, Constitution and Human Rights Society of UPS. And we are very thankful to Dr. Sidharth Luthra for accepting our request for being the keynote speaker for this particular session. Dr. Luthra is known to everyone, and I don't have to give you an elaborate introduction about him. I'm fortunate to have worked with him for some time when I was in Competition Commission, and I have seen him working as an ASG in his avatar there and handling a lot of matters in law and policy. He's a known scholar, and he has done his MPhil in criminology from University of Cambridge, and he is always inclined towards academics, and that is what I find him in number of places as a panelist and speaker. He has written a number of articles, and today's topic, which we are talking about, is rhetoric and reality of capital punishment. And this particular topic, you know, when this topic came basically to my attention, Unlawful Chatterjee's case, 2004, and I remembered for a reason that I had organized a seminar on death penalty at that point in time, because these issues come up whenever there is some death penalty closer to, and then there will be human rights activists and there will be a lot of discussions which will hover around this. But it is indeed a very important topic for discussion and looking forward to it. And there are a number of aspects to this. And I'm sure today Dr. Luthra would be taking us through these niceties and his thought process on that. To moderate this particular whole discussion, we have Mr. Saqib Naru, and we are very proud to have him here. He's our alumni from 2018, and he worked with Justice N.V. Ramana as a law clerk for a year before he joined Dr. Luthra. So thank you to both the moderators and keynote speaker to be here. So now over to you, Saqib, for the further proceedings. So we have 1 hour with us, and we will take questions. Questions will keep on creeping in between in the question answer session, and that is how we will proceed. So over to you, Saqib.
Thank you, sir. Thank you, Vijay Kumar, sir. Good evening to one and all. I hope you are doing well and trying to make the best out of the present crisis. The times are tough, but we humans are perhaps tougher than anything in this world. Before entering into the core topic of today's webinar, I would like to congratulate the Society for Constitutional Law and Human Rights, School of Law UPES, to have organized this webinar and give all of us an opportunity to hear learned senior advocate Mr. Sidharth Luthra on a topic as important as death penalty. Also, it should not go unacknowledged that these webinars are like the silver linings amidst the dark clouds of Corona. And Mr. Sidharth Luthra is undoubtedly one of the most sought after resource personals in these webinars as well, just like his professional practice. Moving on to the topic, the death penalty. A long-lasting and probably never-ending debate about the legitimacy of the capital punishment has pervaded throughout the history of independent India and continues to persist even today, not just in our country, but across the world. Every time there is a question of the fate of the terrorist, or the public vents their views on an appropriate punishment for a rapist, or the court is to decide upon a heinous murder, there arises this dilemma about whether it is right to penalize someone with a daunting death penalty. While there may be a variety of viewpoints that one may consider to formulate an informed opinion about the righteousness of death penalty, a moral and sociological view always proposes a strong perspective against it. However, we should also not forget those who very strongly supports death penalty for heinous offences and proposes it to be a fundamental measure of deterrence. Further, as we have seen over the years, different judicial minds tend to behave differently in the same set of facts and circumstances. For instance, the approach of Justice Nariman and Justice Kurian Joseph has been completely different in dealing with the same set of facts and circumstances. This has led to a debate within legal circles about the legitimacy in awarding death sentence. I'm sure Mr. Sidharth Luthra will throw light on all these aspects. More importantly, because he has had the fortune of standing on both sides of the bar, that is, as a defense counsel, as well as a public prosecutor and additional solicitor general in numerous cases involving heinous offenses punishable with death sentence. For instance, he was a public prosecutor in Nirbhaya case, and he has appeared as an ASG in the landmark case of Shatrughan Chauhan versus Union of India, wherein guidelines for the convicts of death penalty were formulated in 2014. Recently, in December 2019, in the Anokhi Lal case, wherein a man was convicted for murder and awarded death sentence in a trial spanning merely 13 days and stood confirmed by the High Court, MP High Court. This case traveled to the Supreme Court, and Mr. Sidharth Luthra appeared as an amicus and had the privilege of relying on a case pertaining to fair trial, as which was argued by his late father, Mr. K.K. Luthra, as an amicus in the year 1968. Thereafter, the Supreme Court bench, headed by Justice Lalit, set aside the death penalty and ordered a fresh trial. I'm sure Mr. Luthra has much more similar anecdotes and stories to share in today's session. With this, I would request Mr. Luthra to take over the session and enlighten us with his profound knowledge on the subject. Over to you, sir. Thank you for joining us today.
Thank you. Good afternoon, everyone. My apologies for being a little late. There are occasionally technological issues, and for every once in a while these days my email decides not to function. Despite chasing the service providers, there are problems, and therefore I apologize. I've started a little late and I've delayed all of you. So if it is convenient for the organizers, we can extend the session instead of by another 10 or 15 minutes. We can go on till 5:15, so that if there are questions left over, I have no difficulty answering. And Dr. Vijay, if there are, and Sakib, if there are questions which you wish me to answer later, I'm happy to receive. Send me the queries and emails if something relevant is left over, and I will try and answer as best as possible to my knowledge.
Sure.
Death penalty is historically it's a very important issue, but before understanding death penalty, we must also understand the philosophical roots of punishment. Manu's Code of Law, Chapter 7, says that the king should administer appropriate punishment on men who behave improperly. In fact, it goes on to say that if the king does not seriously look at offenders and punish them appropriately, then there would be a situation where the stronger would grill the weak like fish in a spit. Crows would devour the sacrificial cakes. Dogs would lap up sacrificial offerings. No one would have any right of knowledge, and everything would turn topsy-turvy. That, of course, is an English translation by Patrick Oliver on Manu's Code of Law. Herbert Morris, an eminent professor, has this to mention about the core of criminal law. He says that the whole idea behind prohibiting violence and deception is to confer benefit on society. Benefits consist in non-interference by others, but these benefits also require a burden of self-restraint on individuals. And where you don't exercise self-restraint, then for the societal good, there has to be a level of deterrence or punishment. And punishment is therefore justified in a sense that the unfair advantage that the individual has taken, and this is most apparent in our philosophy in the case of commercial crime. The idea is to create a just equilibrium, so the benefits and burden or rather redistributed by the acts of criminals are settled. So the philosophical moorings behind punishment in criminal law are to ensure also that there is no vigilantism. Just earlier this afternoon, I had a chance to look at a serial set in Wales, and there is a group of vigilantism, and then the police officers walk up to them and say, this is a police matter, the law will have to deal with it. And that is the whole purpose of law, and that is the whole purpose of punishment in the criminal justice system, because we authorize the state to take over the responsibility of adjudging guilt or innocence on our behalf as victims, and it is for the state which then determines what punishment, if any, has to be imposed, and the different organs of the state may prosecute. The executive, the investigator is also part of the investigators investigate, And then you have the judges who, as part of the judiciary, are the ones who decide guilt or innocence and also determine the nature of punishment or the nature of deserts to be imposed in that case. So when a court passes punishment, a court is really acting within the confines of Article 21. The court is authorizing the use of state coercion to ensure that there is a action, a response to a crime, a response to what we would call an aberrant behavior by an individual. There is a classic Supreme Court decision of Ram Narayan. It's a 1973 decision, which quotes, and I read, the broad object of punishment of an accused found guilty in progressive civilized society is to impress on the guilty party that commission of crimes does not pay, and that it is both against his individual interests and also against the larger interests of the society to which he belongs. The sentence to be appropriate should therefore be neither too harsh nor too lenient. The Indian Penal Code contains section 53, which provides for a variety of punishment, that's death, imprisonment for life, imprisonment may be rigorous or simple, forfeiture of property, and fine. There is also an element of compensation, and now victims have a right to be heard at the stage, especially of compensation. This talk today is going to focus on the first form, that is the death penalty, though we will touch upon life imprisonment also, because that has been, friends, an important alternative. Initially, it was less so, but now life has been interpreted to mean life till natural life ends, which is the original and correct interpretation. And therefore, there are also intermediate sentences possible, and that is increasingly being looked at on a philosophical and a jurisprudential plane as a legitimate alternative to the death penalty, because the whole principle of law now seems to be, and rightfully so, that apply death penalty in the rarest of rare cases. India is among 58 of the countries across the globe which have not abolished the death penalty. The Law Commission, in its 35th report in 1967, said we must retain it. In 2015, we had another Law Commission report, and this time the Law Commission said retain it only for acts such as terror acts and not others. But that report has not been given effect to. I understand there's a petition pending on some aspects of the death penalty regarding hanging, but that's still pending and notice has been issued. The death penalty in our country can be awarded for a number of IPC offences, for example, treason, abetment of mutiny, perjury resulting in conviction and death of an innocent person, murder, abetment of suicide by a minor or insane person, section 305, attempted murder, 307, by life convict, kidnapping for ransom, 364A, sections 376A, AB, E, rape offense related offences which have been brought in the 2013 Act and thereafter Amendment Act, dacoity 396. There are also offences under other acts, and death sentences in India can be executed by either hanging or by shooting. We also have in the special legislations the POCSO Act section 6.1, punishment for aggravated sexual assault. The Andhra Pradesh Assembly has passed amendments to the IPC introducing the death penalty for rape. It's pending approval of the President following a brutal incident in 2019. Then under the Scheduled Caste Act, the Air Force Act, the Army Act, Navy Act, Unlawful Activities Act, Maharashtra Control of Organized Crime Act, Narcotics Act. All of these have provisions for death penalty. The constitutional journey of this provision is very important, and its validity, how the validity and when it was upheld, is also a matter of some interest. Under the CRPC of 1898, before 1955, awarding death penalty was the rule, and life imprisonment an exception to a person found guilty of murder. However, the 1955 Act 26 of 1955 amended the old code, and courts were now given the discretion to award death sentence or life imprisonment. In fact, some countries such as Malaysia have also maintained this discretion position, and they, as you know, many countries around the world follow the Indian Penal Code. About 34 countries do. The numbers of the provisions may vary, but it's the very same code. In 1973, the position changed completely, and in 1973, death penalty in terms of the new code essentially was treated as one of the special categories, and the normal rule became life. A constitution bench of the Supreme Court in Jagmohan Singh 1973, 1 SEC, it's a 1972 decision, upheld the constitutional validity of the death penalty and held that deprivation of life was constitutionally permissible as it was imposed after a trial in accordance with procedure established by law. Again, there was a challenge in the year 1980, Bachchan Singh's case, because the CRPC, as you know, had made death penalty, as I said earlier, the exception and life imprisonment the rule. And by 355(4)(3), it had become mandatory for special reasons to be given when death penalty was imposed. A majority of the judges negated the challenge to death penalty and overruled the earlier decision, Rajendra Prasad, insofar as it restricted imposition of death penalty only to cases for security of state, public order, and where interests of general public were dissented. Justice Bhagwati had then given a marvelous dissent, pronounced 2 years after the majority. Now, this rarest of rare principle is a very fascinating principle because it interplays two things: rarest of rare and an understanding of aggravating and mitigating circumstances. In Bachchan Singh, 1982 SCC, 684, followed by Machi Singh's case, 1983, 3 SCC, both cases incidentally relating to Punjab. It shows that a lot of these cases, unfortunately, a lot of hurt crime used to emanate out of Punjab. It still emanates from a lot of the North Indian states, not that the southern states are an exception. But both of them held that death penalty should be awarded in the rarest of rare cases. Further, prior to awarding the death sentence, a balance sheet of aggravating and mitigating circumstances is to be made to come to a conclusion whether the possibility of rehabilitation and reformation of the convict is foreclosed, and there is no other alternative than to impose death penalty. Now, here we began to look not only at the circumstances of the crime, but the circumstances of the criminal and the offender to determine, is the person capable of reformation? What were the circumstances that led to the crime? The crime may have been committed, but is it a case befitting the death penalty? As I said earlier, in 2017, a PIL has also been filed challenging the constitutional validity of section 354(5) of the CRPC, death by hanging. Notices issued, I'm told, and it is still pending. Now let's look at the trend. I must tell you, between, the imposition of death penalty should perhaps, after all this interpretation, be more scientific. It should be more logical, it should be more coherent. The courts have laid these principles way back in the 70s and 80s. But we find that it is a very judge-centric philosophy. So by way of example, in the decade 2000 to 2009, you had two sets of courts. You had Justice Sinha's court and you had Justice Prasad's court. The chance of a death penalty being upheld in Justice Prasad's court was far greater than in Justice Sinha's court, who was always keen to reduce it to life. And therefore, there were articles carried at that time that the nature of punishment depended on the bench you landed up with, which is a very unfortunate reflection of our system, because when individual philosophies of judges and courts start impacting sentencing, then there is absence of coherence in sentencing, and there's been a need way too long, and I've been trying to be a votary of it as a humble lawyer. But the concern is, in the absence of sentencing policy, there is always this question: is the sentence adequate or inadequate? Have we been fair to the victims of the crime? Have we been fair to society? Or have we been unfair to the accused and their family? So that tilting, that balance that has to be maintained, will need to be maintained, and hopefully someday in the future, we will not just have judicially ordained sentences or sentencing directions, but a coherent sentencing policy from the state, which will provide minimum and maximum, not just for death sentence and life sentence, but for all class of offences, which hopefully will make the criminal justice system and the scales of justice a little more evenly balanced. I sometimes wonder, we recently had Justice Deepak Gupta speaking about this at his farewell speech, and he mentioned that in Tripura, when he was Chief Justice, there was a painting put up, a mural, and the scales of justice were not evenly balanced. So he was asked about this, and his response was, according to him, the scales of justice are not evenly balanced, and therefore judges must be conscious of it and must try and ensure that the balance is maintained. So the trend, friends, in the last few years has been, as on 31st December 2019, 378 prisoners were on death row, as against 426 as on 31st December 2018. Last year, a total of 109 death sentences were awarded in India, which was a decline from 162 awarded in 2018 and 150 in 2016, and a minor increase from 108 death sentences awarded in 2017. Recent trends show that murder involving sexual offences constitute a large percentage of the death sentences awarded in the last few years, 54% in 2019, 58% in 2018, 43% in 2017, and 27% in 2016. In 2019, the Supreme Court pronounced 27 decisions in death penalty cases, the highest number since 2001. 6 confirmations, 17 commutations, 3 acquittals, 2 matters being remanded for fresh trial. That is the 2019 scoreboard of the Supreme Court. One of these cases, of course, is a very interesting case, as Shakib said, a case called Anokhi Lal versus State of MP. It's a legal aid case which I happened to come into in a very interesting circumstance. While I was waiting as a prosecutor for the Nirbhay case, there was a lawyer, one Ms. Upadhyay, who ran into this Bharti Upadhyay, who was very stressed out because the senior counsel briefed on by her had not appeared in court, and there was no senior. And as you know, in life sentence and death sentence cases in Supreme Court, there is a need, only a senior counsel can argue, that's the norm. So Bharti was in a bit of a fix, and I told the bench, I said, I'll take it on and I'll try and do it. And at that time, I did not think much of the Anokhi Lal case. It was just a brief. I picked it up. And when I picked it up, I discovered a very glaring and tragic situation. The trial had been concluded in as many as 13 days, 1-3. Anokhi Lal has led to another issue. Now the CRPC for certain sexual offences under 309 requires the trial to be done within 2 months, and that has created an aberration in the system that needs correction. And for that, I'm assisting the court now as the mic is curious. But Anokhi Lal was very important to me from 2 perspectives. One, of course, the matter remained pending for a while, and it was pending because at that stage the issue of Sriharan was pending, where the point was whether larger sentences could be imposed or not, more than 14 years, 20 years, but less than life, 20 years, 30 years, 40 years, as the case may be. And therefore, whether they were a legitimate alternative to the death penalty. So till Sriharan was decided, these cases were not taken up. There was another issue. The 2013 rules had brought about a change where they said that there will be a requirement of a 3-judges bench. Also, if you recall, Muhammad Arif's judgment, the Constitution bench had come up, which had said that these matters, reviews must be heard in death penalty in open court. So there was a lot of development towards consideration of how sensitivity that the courts must deal with in death penalty cases. But to come back to Anokhi Lal, it was for me a very emotional moment because I was arguing, relying on a decision of 1969, as Shakib said, Bashira versus State of UP, where my late father had been amicus, and the facts were so uncannily similar that that was the best decision on the point. There was, of course, another case which I had argued in the High Court, which we used, and that is Zulfikar, which was a Pakistani gentleman who was supposed to be a bomber in the Karol Bagh bombings. He comes, gets arrested in this case, he's prosecuted. There are 55 witnesses, out of which the legal aid lawyer appears for the first 5. For 45 odd, the legal aid lawyer does not appear. And then for the last 2 witnesses, we got a very competent legal aid lawyer. And this young lady lawyer not only cross-examined the last 2 witnesses effectively, but also sought permission to re-examine those that had been the witnesses which had only been examined in chief, and no opportunity was left because the counsel did not appear. It was a difficult case. I'd argued it in the High Court on the point that there was not a fair trial. It was not accepted. It was not agreed to. And the matter went to the Supreme Court. I got notice and it was admitted, leave was granted, and the stay against the execution was granted on the same day before Justice Ashok Pan. He granted it on the first day itself. And then when the matter came up, there was a split decision before 2 judges. One said the trial should be quashed, prosecution should be quashed. The other said there was a retrial. Went to 3 judges, and then the 3 judges took a view that the matter is to be sent for retrial. But the fact was that was another important precedent where I had occasion to at least address in the High Court, and I'd argued the matter in the High Court and the initial stages of the Supreme Court. But these cases show us a certain problem that's in the system. And the problem is that in our desire in cases of POCSO, sexual offences and murder cases, especially in the case of minor children, in our desire to comply with the mandate of 309, speedy trial is justice hurried is often justice buried. And that problem, friends, is a serious, serious concern which we have to deal with. But to come back to the statistics, the High Courts have, in 2009, commuted death sentences in 35 cases, 35 in 2018, 32 in 2017, 37 in 2016, which also means that not enough death penalty cases perhaps are either coming up or being heard or considered. In the last 20 years, 8 persons have been executed in India, the last 4 being recently the 4 convicts in the Nirbhaya case in March 2020. The Nirbhaya case was important for another purpose. You know, we had, there was an argument that was made there on the collective cry of society's conscience, the collective conscience of society, and how certain cases, by nature of the peculiar facts attributed to the crime, whether they call for death penalty. There was a very wonderful argument put on behalf of the amicus that society's cry for justice is not a democratic concept and this should not be considered. And can the court really dwell into such a principle? And after a detailed discussion, the court held that while the rarest of rare doctrine has to be applied, but wherever there is there are special facts in terms of the nature of the crime being gruesome or heinous, of an exceptional character, then it is a case relying on the old Bachchan's case and Machi Singh's case. The court said that it must do so in the rarest of rare cases when, and I quote, its collective conscience is so shocked that it will expect the holders of judicial power center to inflict death penalty, irrespective of their personal opinion as regards desirability or otherwise of retaining the death penalty. As always, hoped that this judgment will hopefully be a deterrent, for future grievous crimes. But as we all know, the death penalty has not always proved to be successful in deterring or reducing crime. And that is apparent by the fact that as our population has increased, there is also an increase of crime. So in Mukesh, the court also held one more thing. In Mukesh was the Nirbhaya case, and I quote that portion, para 511, when a crime is committed with extreme brutality and the collective conscience of society is shocked, courts must award a death penalty, irrespective of their personal opinion as regards desirability. By not imposing a death sentence in such cases, the courts may do injustice to the society at large. Now, but death penalty cannot be imposed in a vacuum. You may recall I spoke about mitigating and aggravating circumstances. So even in determining the rarest of cases, the rarest of rare cases, society's collective conscience of society, we also have to see factors such as age of the accused, health of the accused, as I said, possibility of reform, rehabilitation, family background. That was another thing that was argued. And also we must also see the absence of criminal antecedents. And in a recent decision in April 2020, in Arvind Singh's case, the court unfortunately seems to have held that young age and absence of criminal antecedents of the accused are not mitigating circumstances, but what is to be seen is a possibility of rehabilitation and whether it's a rarest of rare case. Now this, friends, has created a bit of a conflict. On the earlier view was age. So if a person is, let's say, in his 70s or 80s, you don't want to necessarily give the death penalty because you know the person is almost at the end of a life sentence would suffice. Or if a person is very young and there is a chance of the person's rehabilitation or reformation, then why award the death penalty? But yet, the new view seems to be that the principles of death penalty are undergoing further change and becoming a little more stringent. We've also had cases where death penalty used to be awarded on the same day, and that was very disturbing. So in Alauddin Mia, 1981, interpreting section 235 of the CRPC, it was made clear that when you're imposing death penalty, you must give adequate time to the accused and he must be given a right to hearing because you have to see the circumstances of the offender. In the recent case in Nirbhay, this argument was raised that adequate time or opportunity had not been given at the time of imposition of death penalty. And the courts not only called for a report and a verification, but they also called for affidavits from all the accused. And after satisfying that the accused had adequate opportunity, even at the Supreme Court, only then and then after due consideration was the death penalty imposed. And I believe that even in the trial courts, if the death penalty is imposed without due consideration, that aspect is rectifiable at the High Court, which is the first appellate court where the reference takes place, and otherwise in the Supreme Court in any case. And it becomes very important when it is done. Because we must keep in mind that in a death penalty case, High Courts are not merely courts of appeal. There is also a reference where a consideration is to be made whether death penalty is or is not to be imposed, and automatically a reference goes to the High Court, which is called in some courts the death reference. And it is important because our principle that the death penalty must be imposed in the rarest of rare cases has to be mandatory followed. That is the law. That is the philosophy of our criminal justice system, and we cannot but abide by it. No discussion of the death penalty is complete without a discussion about the Mersey Jurisdiction. Now, what is this Mersey Jurisdiction? In cases where a person is given up imprisonment or punishment, there is power under the CRPC to reduce the punishment imposed. There is also power under Article 72 and Article 161 of the Constitution of India to mitigate or reduce the sentence. And this is a prerogative power. It's a power which dehodes the guilt. So sometimes you will find cases where the evidence exists to punish, but other circumstances are considered, and this power, in that classical case of Biddle versus Perovich, the US Supreme Court said, a pardon in our days is not a private act of grace from an individual happening to possess power. It is part of a constitutional scheme. When granted, it is the determination of ultimate authority that the public welfare be better served by inflicting less than what the judgment fixed. This principle of law has been followed in a number of decisions, including the classic case of Epuru Sudhakar versus Government of AP, 2006, 8 SCC, 161, para 16. Now, these provisions, 72 and 161, give the president, give the governors of the states the power to reduce the period of sentence to commute, change the death sentence to life, and even reduce the sentences undergone by, as I said, overriding the guilt of the convict. But in the exercise of these powers, both the Honorable President and the Governor do not act of their own accord. They are to be bound by the advice of the appropriate government. There are, of course, instances, for example, when Dr. APJ Abdul Kalam was the Honorable President of India, His Excellency did not believe in the death penalty. So he kept these matters pending. He would not accept that advice. He kept these matters pending, and it led to various peculiarities later. It led to that entire slew of decisions in the Shatrughan Chauhan case, because he was wary of imposing in death penalty cases. He kept the matters pending, and where there had been rejections and matters had come up to mercy petitions. And similarly, the Honorable President, Madam Pratibha Singh Patil, who followed, also kept a lot of these matters pending, as a result of which we reached a situation when the former president, Dr. Pranab Mukherjee, President of India, had decided a lot of these cases. A slew of petitions reached the Supreme Court, and there were two batches. One was the Shatrughan Chauhan batch, and the other was the V. Sriharan batch, which is the assassins of the late former Prime Minister of India, Mr. Rajiv Gandhi, and I'll dwell with that in a moment. But as I said, this power can be excised, should be excised, and what is most important is advice of the government. Of course, this power, the refusal to exercise such power, can be tested. So if it is perverse, and it is tested on the narrowest of grounds, that has been settled in Triveni Vain's case in 1989. You can't just challenge a refusal to entertain a mercy petition except on the most special of grounds. There is, of course, as I will deal with it a little later, the issue of mercy petitions is not a very regulated area. The effect of a mercy petition, of course, is that in a death penalty case, the moment a mercy petition is lodged, the sentence is not to be executed till the mercy petition is decided either which way, either by Honorable the Governor or by Honorable the President. There is, or at least was, no real straitjacket formula for awarding the death sentence, and therefore there was also no real straitjacket formula before Shatrughan Chauhan looked at this closely, and when there should or should not be mitigation of the death sentence. But principles such as recommendations by jail authorities, economic deprivations, ill health of the convict are all guiding factors. There are cases and cases, there are certain parameters in the jail manuals, but they have been applied perhaps not as consistently as we would desire. So many convicts will end up languishing in jail, depending on the time that their death penalty is afforded, depending on the president who's considering the application, and whether the president believes in a philosophy of clemency or will not accept the government's advice and keep the file pending or send it back for consideration. Now, Shatrughan Chauhan is a very interesting case, and I have a personal connect with these cases. The day I joined as a law officer, I think 2 days later, I joined on the 6th of July 2012. On the 7th, it was a Friday. On the Monday, 7th, 8th, 9th, I think it was the 9th or 10th of July 2012, I was sitting in this very room, possibly in this, not in this chair, but in this very place. And I had two officers of the government who took an appointment, came in. There was a joint secretary of the MHA. He came in with a case called Sriharan and Union of India versus V. Sriharan, where Sriharan, the assassins of the late Prime Minister Rajiv Gandhi, former Prime Minister, were seeking clemency, had filed petition to the Supreme Court, saying that the delay in deciding their mercy petitions had led to a position where the death penalty ought not to be imposed on them, because the long pendency of time while incarcerated on death row had caused them utmost cruelty, and therefore there was no justification in imposing the death penalty so many years later. Well, that was, as I said, one of the first cases that came to me, but that case was not to be heard or decided at that point, and the file, though it remained on the regular board, went up and down and was not heard for a very long time, almost for 1.5 years. About 1.5 years later, there were a number of cases which were decided by the then president, Dr. Pranab Mukherjee, who took a view on a number of death penalty cases, and those cases reached the Supreme Court in the Shatrughan Chauhan batch of petitions, and eventually it was argued, I was one of the arguing counsels, there was the Solicitor General, Mr. Mohan Parasan, and my Lord Justice Nageshwar Rao, who was then an additional Solicitor General and a colleague of mine. So all three of us argued the matters in different points, different aspects of the matter. But in Shatrughan Chauhan, the Supreme Court felt that most cases where there was a great delay, death penalty was being quashed and commuted to life sentence. The principles were that when there should be no solitary confinement for death row convicts, legal aid should be provided, superintendent of jails must intimate the rejection of mercy to the nearest legal aid center, communication must be done to the family, they must be given minimum 14 days, they must be given opportunities, mental health evaluation should be done, documents should be furnished to assist the accused in making a mercy petition and to petition the courts, and the final meetings had to be done. So a number of guidelines were given, and there was a recommendation that the government should consider bringing out statutory norms so that there is coherence in the manner in which death penalties are imposed and how they're executed, and especially how mercy petitions are to be dealt with. Unfortunately, despite this judgment coming in 2014, nothing much has been done. This judgment was followed by the Sriharan case. Sriharan is very important because in Union of India versus Sriharan, when this case, as I said, was an earlier case that came to me, but in one of the vagaries of the registry of the Supreme Court, happened to come up a little while after Sriharan. So here we were faced with a situation that Sriharan had come, and we really had, where Shatrughan Chauhan's decision had come, and because there had been a delay of, if I recall correctly, about 11 years since the death sentence was imposed, and last petition that had been dismissed before the Supreme Court, it seemed clear to us that there would be a life sentence almost automatically. I was led in that case by the late Ghulam Mahanvati, the then Attorney General, and we put up the best fight we could at that point of time against difficult odds. And of course, we lost. What happened the next day was amazing. The Tamil Nadu government immediately issued a circular that the sentences of these accused would be as undergone. And they'd all spent fair amount of time in custody, 17, 18, 19 years, as the case may be, because the incident was in 1991. Now, this led to a lot of concern for us, because we were now concerned as to, on behalf of the government, because nobody, I think, had expected that this would happen. So immediately the next day, we moved a miscellaneous application and later filed a substantive petition. And that petition is known as Union of India versus V. Sriharan. And that dealt with a number of issues, whether the center of the state has power in the case of, depending on the nature of offenses, to commit or to commute or remit sentences. And that was one of the issues that had been done, because in the Sriharan case, some offenses were punishable, were under central acts, and there was a CBI investigation. The second and most important thing was the old principle of Swami Shraddhanand. Now, I was going to talk to you about Swami Shraddhanand. You know, in the Godse case, the issue of life being life was settled. It was a constitutional bench. After that, by government orders, life began to be treated as 14 years or 20 years as the case, maybe 12, 14, 20 years. And that was the maximum life is to be considered, because the moment person completed 14 years, he was entitled to release. In Swami Shraddhanand's case, the issue of sentences intermediate up till natural life and intermediate sentences of 20 or 30 years came up for consideration. And there was a different view. There were 2 judges who disagreed, and then it went to 3. 3 took a view that you could have intermediate sentences, and then this again became the subject matter of consideration in Sriharan, and that was one of the questions framed. And therefore, it became very important, because Sriharan decides a number of issues, including the fact of intermediate sentences. Now, these intermediate sentences are very important for us, because they are also a very legitimate alternative to the death sentence. So if you give a person a sentence, let's say, for 30 years or 40 years, you're not taking away their life, but you may end up releasing them either when they are no more, as a matter of age or ill health, or when they reach a point in their lives when they are ineffective and unable or incapable to do harm, where you believe that the person can't do any harm. But that is an issue which will have to be seen, because while this law, while this is provided as a matter of precedent, we still do not have clarity as to when they ought not to be applied and when they should be an alternative to the death sentence. I must also share with you, friends, a few more things before I wind up, because I understand Dr. Vijay Singh is looking at me eagerly. I think I'm extending my time.
No, you are not, sir. Actually, I was just looking at the questions which are coming up, and I find that you are already addressing most of the questions. I can only find one question which is quite intriguing, and while you continue your talk, you can address that. Is why do lawyers take this particular cases of this death penalty accused? So that is quite an interesting question.
I will deal with that. I will deal with that towards the end. But let me explain this. Sure. Let me just do a little more, but that's an important question.
Right.
Now, as I said, one of the cases, one of the questions that came up, and one of the issues that's been asked to me again and again is, in the Nirbhay case, why are there so many challenges? Why was the death penalty not carried out earlier? There are two responses I have. The first response is, after the curatives, reviews and curatives had been dismissed, what stopped the jail authorities and the administration from acting? That's a legitimate question we need to be asking. Why did they only act at a certain point of time? Why did they only wake up on a certain day? This has to be stopped. The moment the challenges are over, you cannot necessarily delay it, because then you're really allowing an abuse of process of law by delaying the death sentence and giving the person another opportunity to say, because of long non-imposition of the death penalty after mercy petitions are over, we now have an opportunity, we now have a position where the death penalty ought not to be imposed. Having said that, I must also point out that I believe that there have to be parameters about the number of mercy petitions that have to be filed, the number of challenges, and the time set out for those challenges. Human life is precious. When society wishes to take away somebody's life, there must be adequate opportunity. We must not act in haste, and we must not act as if we are sitting on primetime TV at 9 p.m. and passing judgment, as tragically is done in criminal cases on a daily basis. That is abhorrent to the rule of law. That is abhorrent to a society which believes in the presumption of innocence. That is abhorrent to a civilized society. And whether we stand on the right of the fence or the left of the fence, or as people like me choose to be in the center, the fact is we have to be fair to both the victim and the accused and to society. All three parameters must be met. I will just end by sharing the position on the recent on some recent developments, which my worthy colleague Mr. Shakib Naru has been very kind to provide to me. He's done some good research for me, and I'm very grateful to him and to Mehak Jaggi in my office. India voted against the abolition of death penalty in the 42nd UN Human Rights Commission session. In 2016, again, they voted against the UN resolution. So one thing is clear, we are not willing to let go of the death penalty. In Raju Jagdish Paswan, state of Maharashtra, a case decided in 2019 January, we lay down a principle that death penalty can only be imposed when the alternate option of life or extended imprisonments is unquestioned. Interestingly, certain judges, retired judges, Justice Joseph amongst others, have taken a view that there is no proof of death penalty as a deterrent to crime. While I was arguing the Nirbhay case, I came across a very interesting decision by two judges of the Supreme Court. And it was a division bench. And I found that almost in the last para, it was edging towards the death penalty, and in the last minute, it changed from death to life. I don't want to mention the name of the judges, but at one point, at a social occasion, when I was speaking to the senior judge, he mentioned that he had planned to give the death penalty in the facts because they were very peculiar facts. But the reason to give life was because his brother judge, his co-judge, requested him that the co-judge had never given the death penalty, did not believe in the death penalty, thought it was abhorrent, and therefore requested that death penalty ought not to be imposed. And that is the reason the sentence was life. Such precedents, unfortunately, create problems for us as students of the law. It creates problems for judges, it creates problems for students of law, because there is no coherence and no consistency that will arise from such decisions, which philosophically wish to say something, but the conclusion may be different. In 2018, Justice Joseph again talks about the 35th Law Commission report, 262nd Law Report, tells out the stark differences and says that now there should be an abolition in most cases, relying on the 262nd report, which is the 2015 report. But these reports are mere recommendations of the Law Commission and not put into force in law. In another recent case, in Ravi's case, the 2019 amendments to the POCSO Acts were considered and death penalty was imposed. In a case which I recently argued from Tamil Nadu, the death penalty was upheld. It went to 3 judges. We argued and reviewed it at great length, but the court has taken a view, though one of the judges has disagreed and has given the dissent both at the stage of principal judgment and at the stage of review. The abolition of capital punishment bill was introduced in Rajya Sabha but later withdrawn. And as I said, the Andhra Pradesh Legislative Assembly passed the AP Criminal Law Amendment on 13 December 2019. Matters pending with President whether rape should 376 requires a death sentence or not. To answer the question Dr. Vijay Kumar put to me, his query was, why do lawyers take on cases of death penalty? Please remember, most cases of death penalty are by the poorest of poor. These are people who have limited access to justice, as I told you in the Enoki Lal case, or the case in 1969 of Bashira, which my father did, where justice was written roughshod to the Supreme Court. Now, in all such cases, we find that people who are incapable of representation end up with harsher sentences. I would recommend to any of my young friends to visit any high court in the country. And I say this with a sense of confidence. Barring the Sikkim High Court, I've appeared in every high court in this country. When you go to the division benches, which deal with cases of 10 years and life imprisonment and death penalty, you will find, by and large, cases represented by young lawyers, by legal aid lawyers, and rarely do the doyen of the criminal bar come there, except in certain cases where the work is towards hurt crime. In certain courts like Madhya Pradesh, where their work is hurt crime. Today, increasingly, the best of the criminal lawyers are doing white collar crime, and you will find them in the single benches doing quashments, revisions, bails. Appeals in single benches take a lot of time. And the problem that we face is there is inadequate representation from the trial court till the Supreme Court of those who suffer the harshest imprisonment. I believe that everybody has the presumption of innocence. Everybody has the right to be defended to the best of by the best of lawyers, to have the most appropriate and the most effective legal representation, whether at the stage of conviction or at the stage of sentence. And the day we start passing moral judgment, as some people do, as I said, at prime time television at 9 p.m., when they determine innocence and guilt, and members of the legal profession are equally responsible when they start judging people's guilt or innocence on the evening on television, then we have a problem, because we are not true to the law. We are true to our personal beliefs. And representing the state or representing the defense, we have to be true to the law. Let me also point out, the Bar Council rules in India, and similarly almost in most common law countries, require that the prosecutor must make sure that exculpatory evidence, exculpatory material must be available to the accused. The purpose behind the cleavage between the prosecutorial service and the police. Prior to 1973, you had prosecuting sub-inspectors of police who used to be prosecutors. After that, the prosecution was separated from the police, brought under the executive part, the civil administration, and not under the police, and was separated, except in CBI, where they effectively are one and the same, though they are lawyers, but they really operate under the aegis of the CBI. But that separation became important because you want the prosecutor to be fair and not just to toe the line of the investigator. Unfortunately, there is a practice of challan checking, charge sheet checking, which is prohibited by law, prohibited by the Supreme Court decisions, but state governments, because of lack of resources, end up getting the prosecutors to check the police charge sheets and give recommendations, as a result of which prosecutors sometimes may lose their complete independence, and that is detrimental to the system. Therefore, I would end by saying, everybody in this country or elsewhere, in every civilized society, has a right to be defended from the beginning to the end, merely because there are opportunities such as, and I say this though I was a prosecutor in the Nirbhay case, merely because there are multiple opportunities and the law is not coherent on the number of opportunities you can have to defer or deter your death sentence, does not mean that people have misused the law. It means that the lawmakers need to frame appropriate regulations and then implement them. Don't blame the accused, don't blame the victims, blame the lack of regulation, the lack of coherence in our philosophy. Thank you very much.
Thank you so much, sir. That was indeed an insightful session. We have a lot of questions pouring in. So if you have time, sir, we can go ahead with few questions.
Let's take 10 minutes on questions.
Yes, sir.
I think I've covered some of the questions, though.
You have, sir.
There are, I can see there are lots of questions that have come. There's one question I must ask. Do you think the continuous bashing of AP Singh, the counsel for the accused, is likely to discourage lawyers from taking up cases? He was a lawyer in the Nirbhay case. I don't think he's been bashed up, but sometimes I feel that the submissions made on behalf of the accused in the Nirbhay case were did not serve their cause appropriately, and that is the reason in the Supreme Court amicus curiae had to be appointed. And I'm glad that the Supreme Court was sensitive, appointed two very eminent lawyers, Mr. Raju Ramachandran and Mr. Sanjay Hegde as amicus curiae, so that the principle that justice should not only be done but to be seen to be done was fully applicable in that case.
Yes, sir. Sir, one more question which is coming from the faculty member, Saksham Pradyut, sir. He has asked you to comment on similarities and differences between judge-centric and jury-centric philosophy.
We did away with juries because we believed that juries did not really reflect the legal principles in their decision making. That's why we did away with juries in India. But when we find that individual philosophies cloud decision making, then perhaps judges are not as far from juries as they ought to be. The whole idea behind having only judges is that you have a trained judicial mind, a person who understands the law, the philosophy of the law, sentencing, has the ability to appreciate evidence, does not require constant guidance. Juries require constant, often guidance, often from a judge on a point of fact or of law, because they're not trained legal people. But that's not the case with the judge. And therefore, my belief is that we need to have more some level of guidance to judges so that the aberration in sentencing is reduced. The aberration in analysis of evidence, if any, is reduced. That's the requirement of the day to make it a fairer, a better system.
Yes, sir. Thank you, sir, for that. Sir, one more question. That is, an application was moved by an accused in Nirbhaya case at the ICJ. Does ICJ has jurisdiction in these type of matters?
I don't think so. I don't think so. There are a number of questions I can see, lots and lots.
Yes,
most of these questions seem to be about the Nirbhaya case. We should have just done this as a talk on the Nirbhaya case, perhaps.
Yes, sir. So there is one question indeed, which is, I think, not related to Nirbhaya.
I think it is the latest death sentence which happens is actually the focus of the study many a time. So,
sorry, I'm sorry, I missed that part.
Yeah, I am basically saying that the latest death penalty which has been imposed, that remains the focus of the study, because this young generation, they have seen it immediately and then they have a lot of questions, both sides. In fact, in this case, this was completely other way around. I have seen death penalty, marches happening against death penalty, but this was for death penalty. So it was quite, how do you balance that particular aspect? Like, what is your view on that?
I think there are speaking for myself, we have now done a corrective in our criminal justice system by recognizing victims' rights. We have chosen to allow victims a space in the criminal justice system. In fact, it so happens that the case which has decided this issue partly is a case called Rekha Murarka, where I was appearing in the Supreme Court for the petitioner. Having said that, there is one thing I must add. The individual's or public right to protest or demand something is a right under Article 19. It's a right of freedom of speech and expression. That right is an independent right. But the right under Article 21 of the victim and the accused to a free and fair prosecution or trial, the right for an accused not to be deprived of life or liberty except by procedure established by law, is, according to me, the more crucial right in a criminal prosecution or a trial, especially in the death penalty. And while the collective cry of conscience has been accepted as expressed in the Nirbhaya case, that needs to be seen very carefully. It does not mean that protesting on the streets of Delhi or protesting on the streets of India or elsewhere should impact the mind of judges. All the collective cry of conscience means that judges must see the nature of the crime and its impact on society objectively, not subjectively. And that's the distinction the decision makes. Otherwise, we would be in an era of majoritarianism, which is exactly the thing that was argued for on behalf of the accused by the amicus, and that is something which is abhorrent to a rule of law regulated society, civilized society.
Great. Thank you.
Thanks a lot, sir. I think, sir, you have already covered most of the questions which is pouring in from the attendees, and there is most of them are very much similar and related to Nirbhaya, as you said. Others you have already covered. So I think if there is,
there's one thing I want to say. There's one thing I do want to say.
Please, sir, please.
There's a question, there is a point that has come, which I was noting in the chat on unregulated media. And it says unregulated media can lynch you, a gentleman by the name of Akshat Mehta.
Yes, sir.
I think regulation of media or regulation of anybody is important. But today, we express our opinions not just on the electronic media or press. On social media, we determine people's innocence or guilt. We create reputations because the anonymity of the medium allows us to express things which we, in personalized conversations, may not. In one-to-one conversations, may not. Therefore, I believe that it is time for us as a society to think, should we not exercise a greater self-restraint, not just in determining the innocence or guilt of people, but also be a little more respectful of each other and each other's rights. Whether it is Article 19, 21, 14, all are equally important. Whether it is the rights for women, children, religious rights, community rights, every right is important. But for that, there is a need for greater self-restraint. And sometimes I, speaking for myself, though I represent a lot of the tech companies in the social media business, I must confess, I believe social media and even unregulated media come too close to breaching legal provisions, especially in the criminal law. And that's because of the nature of the medium. And as a society, the more we lap it up, the more we are doing damage to the rule of law. Because I speak as a lawyer and no more. I'm not a sociologist, but my understanding as a lawyer is we damage the rule of law. In the Sahara case, 2012, there was a concern about the extent of reporting, and I remember having appeared there. I put down a number of instances where the impact of decision making, there is an impact on decision making. And I'll tell you a story. When I used to, as a young lawyer, when arguing in the trial courts in Delhi, I would find that I would go to a judge and I would say, I need anticipatory bail or bail. And they would tell me, Mr. Luthra, go to the Green Building. That time the Delhi High Court, which was close by, was colored green. And they would often turn around and tell me, have you not read the paper today? This case was all over the news. Well, cases are always going to be all over the news. But are we going to be impacted in that? Are we going to let ourselves be affected by that? And as people in the field of law, that's something we need to understand. That is the distinction between a lay person and a lawyer. That's all I wanted to say.
Thank you so much, sir.
Thank you. That is indeed, I would say, a complete composite course on death penalty. And I believe
yes, sir.
Students of criminal law would have enriched a lot with this. And we will have this particular recording also put up for our students, and then we will utilize this for larger purpose. Over to you, Gautam. We are constrained with time. I know we have already exceeded. So, Gautam, for vote of thanks.
Thank you, sir. Very good evening to all the panelists, to all the attendees, and I extend my thanks to Sidharth Luthra, sir, from the Society of Constitutional Law and UPS School of Law for accepting our invitation and to speak on the topic. So very well explained the topic from the legal provisions which are there for death penalty, from the approach of the Supreme Court regarding and the viewpoint of the judges there, India's approach to at the international forum. So sir has covered very beautifully and in a very detailed manner. Thank you so much, sir. And I also thank Saqib sir. Sir has been a very helping hand in our college. He still used to do that. I also thank VK sir, our dean, for providing all the support, our faculty convener, Ashutosh sir. And I also thank the technical team which made this event possible. So thanks a lot. And I wish after the situations became good, we will have Sidharth sir in our campus. So I also invite sir to visit our campus, and if the situations.
Thank you so much.
So thank you so much everyone for joining us. We have listed all your.
Thank you, Gautam.
And we will try to put those questions to Saqib sir, and let's see if we can get the reply. Thank you so much.
Thank you.
Thank you. Thanks a lot.
Thank you, sir. Thank you, Siddharth, sir.
Thank you.
Thank you.